Everyone, Dustin from lawatyourSide.com. And did you get injured at work? And was it your employer's fault or were they negligent? Can you sue them because of that? Today, I'll answer that question. So a long time ago, a law was passed in this country that said if you are an employee and you're injured at work, you cannot file a civil lawsuit against your employer. Instead, you have to pursue a workers' comp claim in the workers' compensation system. So difference between a lawsuit and a workers' comp claim is a civil lawsuit, you're going to a civil court and filing a lawsuit basically saying your employer or the other person did something wrong, they were negligent, I got injured or whatever as a result, and you want compensation for those. Workers' comp claim is much different. You're not technically suing your employer when you file a claim. I know a lot of clients ask us that, am I suing my employer? Technically, you're not suing them, you're just filing a claim for benefits, and it's in the administrative court, the Workers' Compensation Appeals Board. So those are two very different processes. Those are two very different things. So technically, you're not suing your employer. Now, that being said, there is what's called the workers' comp exclusive remedy rule, meaning you have to pursue the workers' comp claim against your employer. You cannot file a civil lawsuit against them. If you try to file a civil lawsuit, the employer's attorney will file what's called a demur or a motion to strike, or there's a bunch of different motions that they can file. But basically, they're going to dismiss your civil claim and say, go back to the workers' compensation system, and that's where you're stuck. So today, I'm going to tell you some of the exceptions to that rule. But just know that generally speaking, you have to pursue your claim in the workers' compensation system if you are an employee and you got injured while working. So one of the main exceptions to this rule is if your employer did not have workers' compensation insurance. So there's a labor code that states that all employers must have workers' compensation insurance for their employees. If they don't have it, guess what? You can file a civil lawsuit against that employer. So you don't need to pursue workers' comp anymore. You still can if you want to, but you can file a civil lawsuit. Generally speaking, civil lawsuits can be more lucrative. There's more benefits involved. The medical treatment's a lot smoother, cleaner, and easier than it is in a workers' comp case. So that is one way to file a civil lawsuit against the employer. In order to do that, you have to determine, do they have workers' compensation insurance or not? There's a way to check online. There's also an official way where you submit a form to what's called the WCIRB. They come back in about 3 to 4 weeks and they tell you yes or no, does this employer have workers' compensation insurance. Second major exception is if you as the injured worker are working for a contractor, okay, and that contractor is required to have a contractor's license, but they do not. In that case, even though they might have workers' comp insurance, but if they don't have a contractor's license when they are required to, then their workers' comp insurance is going to be deemed invalid, and you can file a civil lawsuit against the general contractor. So again, you don't have to go the workers' comp route. You can now go the civil route against that contractor. Exception number 3 is what's called the power press exception. What this means is if you're at work and you're using a specific machine called a power press, or it acts as a power press, and what a power press is, it's a machine that stamps maybe through clothing or on a license plate or something like that. What a lot of times employers do is there's supposed to be a safety guard on these power presses so you don't get your hand stuck there, but they remove the guard so you can move more quickly, and what happens is your hand can get stomped by the power press. So if that's the case, you're using a power press and the employer removes the guard and your hand gets injured, very specific kind of case. But if that's the case, there's an exception to the workers' comp rule where you can then file a civil lawsuit against the employer. You're not stuck in the workers' compensation system. Next exception, again, very rare, but it happens sometimes, is what's called fraudulent concealment. What that means is if the employer knows that you, the employer, are working in some building or environment and there's toxic chemicals there, or maybe you're out in the field and there's toxins out there, they know you're out there, they know there's toxins out there, they know you've been exposed and they're not telling you anything, civil lawsuit, don't have to do it in workers' comp. Now, there's derivative cases as well. So let's say you are working, you get injured, and then you get fired as a result. Or you're being discriminated against because of your disability or your race or your sexual orientation, something like that. That all falls outside of workers' compensation system. The basic premise is when you go to work, you're not trading off the idea that, hey, I'm going to work for you and in turn you're going to discriminate against me. It's not a benefit of the bargain, so to speak. So if that happens, it's considered outside of the workers' compensation system. You can file the civil lawsuit. Next exception is a physical altercation by the employer. So maybe it's your manager or the owner or somebody like that attacks you or hits you or threatens you, something like that. That's, again, not contemplated by the workers' compensation system. And because they're a person in authority, you could go the civil lawsuit route. If it's a coworker, it's going to be a little bit trickier because they're not necessarily in a position of management or from the employer directly. So it's going to be a little bit trickier. But if they are like the owner or high-level management, potentially you could do a civil lawsuit even against the employer. Next exception is for pregnant mothers. So if a mother is pregnant and they're at work and something at work happens and something happens to the baby, civil lawsuit against the employer because the baby obviously is not an employee working for the employer. So the baby's interest has a completely different interest than the mother's interest. So that civil lawsuit can be pursued in that kind of case. Another semi-big exception is whether you're an independent contractor or an employee. So workers' compensation applies to employees only, but if you're an independent contractor and you're injured as a result of your employer, you could potentially pursue a civil claim against the employer. So those are some general exceptions to the workers' comp exclusive remedy rule. Now keep in mind, some of those exceptions, you still have to find some sort of liability against the employer, like you're an independent contractor and you're driving, you get injured as a result of someone else, your employer may or may not have had anything to do that, so there's no liability on the employer there. So there has to be some sort of liability or they did something wrong in order to prove up the case. But those are the general exceptions, so I hope that helps. Thank you so much for watching that video. If this video helps you, please click the like button below and subscribe to our channel. Also, if you want a free consultation or for us to help you on your workers' comp case, please give us a call at the number below and we'll be more than happy to discuss it with you.